That's good, yeah. That's good,
Yeah. Hi, everybody. My name is Peter LaRue. I'm an executive consultant in the Employment Law Department at ENSafrica. Welcome to this first of our pop-up webinars, which will be presented by our department. Until now, our principal way of communicating interesting legal developments to our clients has been through the use of ENS sites that are written by members of our department and published regularly on our website and distributed in other means. We, however, feel that there is another channel for discussion or for inviting or providing information to our clients, and that is what we have now termed the pop-up webinar. The idea is that if an important decision comes to flight or another important development takes place, we will convene a pop-up webinar at relatively short notice. And this webinar will provide a forum within which our senior executives can interact with our clients, discuss this development and its implications. We hope that these webinars will be short and sharp in the sense that they will last no more than 40 minutes. The speakers will be succinct and concise, and we hope that the questions will be the same. We have been advised by those who deal with these matters that 40 minutes is the sort of ideal length for a seminar or webinar, and we hope that we can keep to this deadline. The aim of this webinar is to discuss the implications of the recent decision of the Constitutional Court in the Commercial Stevedore Agricultural and Allied Workers Union versus Oak Valley Estates Pty Limited and another. A long and clumsy title. It's an unreported decision, and we will give you the reference at the end of the seminar. This decision was handed down on Tuesday last week, and we can in the position to discuss it today, just over a week from the date that the decision was handed down. To discuss these topics, of our panelists will be Dion Masher, Baladili Shazi, and Fritz Malon in Johannesburg, and Irvin Lawrence in Durban. They're all senior members of our department. They are seasoned litigators in the field of labor law, and I'm certain that they will be able to give us some important insights into the case and into the developments. We have provided time for participants to pose questions or make comments. You will note at the bottom of your panel, you will find a question and answer button that you can press, and the answers of the questions will come through to us. Right, in accordance with the idea of making it a short and sharp and succinct presentation, I'll now hand over to Dion Masher, who will provide a summary of the litigation thus far in the Labour Court, the Constitutional Court, and the Labour Appeal Court. Thank you, Dion. Over to you.
Thank you, Peter, and good morning to everybody. As Peter said, this citation is a long one. I'm going to just refer to it as the Oak Valley decision. So Oak Valley is a business in the Western Cape, and they have had some issues regarding alleged discrimination, specifically around the allocation of employee housing as well as seasonal employees claiming that they should become permanent and no longer fixed term but indefinite term employees. And those two issues remained unresolved. It culminated in a strike, a protected strike in May 2019. The parties could not agree picket rules. So strike and picket rules were determined and implemented by the CCMA. It's noteworthy that the CCMA, and it was common cause, noted that with previous protected industrial action at Oak Valley, violence was always something that arose. And so the parties were certainly alive to this. The strike commenced, and lo and behold, there was violence, intimidation, damage to property, and it extended to include community members, as well as the blocking of a national highway, the N2. Now, the issues around unlawful behavior, misconduct was not in dispute. That was common cause between the parties, and notwithstanding this, the violence and the unlawful behavior continued. The employer then went to the labor court and sought to interdict the unlawful behavior. Importantly for our discussion, the respondents that they had cited were firstly the trade union involved, secondly, the employees who were members of the trade union, as well as the labor broker that had the seasonal employees as their employees. And then a third group of individuals were cited, and they were labeled the unidentified or unidentifiable respondents. At the labor court, the court was satisfied that the employer had shown and complied with the necessary requirements for an interim order, a rule nisi, and that was granted, notwithstanding that the trade union and the respondents raised an argument that there was no proper identification of individuals linking them to the common cause incidents of intimidation and unlawful behavior. The courts found, the labor court found that that wasn't necessary at the time. A third point raised by the respondents was that there was alleged breaches of the CCMA imposed picket rules, and notwithstanding that there had been no dispute referred by the employer to the CCMA to deal with those alleged breaches. And then thirdly, the issue, well, the third issue we don't need to actually discuss. It's not relevant for these purposes. So that was the labor court. The labor court granted the rule nisi and the interim order, and the trade union and the respondents then anticipated the return date, and less than a week later were in court to argue the discharging of the rule nisi. So the employer wanted the rule made final, the respondents wanted the rule dismissed, discharged. And the arguments then that were raised in the labor court were again raised, and the court dealt with them, and there was a final order granted. That then went on appeal to the Labor Appeal Court. And at the Labor Appeal Court, the respondents argued the same issues. And for our purposes, the issue regarding whether there was a necessity in our law to link individuals to the unlawful behavior became a significant issue. The second issue was whether or not an order that did not allow employees to come within the premises, the workplace, unless they were tendering their services, was also a point taken by the respondents on the basis that that constituted an eviction order, because on the facts of this case, there were employees who were accommodated in hostels on the premises, on the workplace. And then the third issue was the issue around the employer's failure to refer dispute to the CCMA regarding the breaches of the picketing rules. The Labour Appeal Court dealt with all of these issues. On the secondary issues of an eviction order and the referral of a dispute for breach of picketing rules was dealt with, and the court agreed with the respondents. The court found that the effect of an order not requiring employees to report for work or otherwise stay within 800 meters of the workplace was effectively an eviction order. So they set that aside on appeal, and also found that in terms of the LRA, a dispute was necessary prior to going to court to obtain an interdict where you allege breaches of picketing rules. And then on the primary issue of identification of individuals and linking individuals to misconduct and unlawful behavior, the court agreed with the Labour Court, this is now the Labour Appeal Court, and said that it's a breach too far within the context of South African industrial relations. And the court did not find that the bar was that high in terms of our law. And so the matter then proceeded to the Constitutional Court. And it's that decision that we are going to discuss in more detail today around the Constitutional's now final word on the issue of primarily the identification of individuals during strike action and unlawful behavior. Thanks, Peter.
Thanks, Dion. Fritz is going to discuss the decision itself and the legal reasoning behind the decision. Fritz, over to you.
Thank you, Peter. The Court looked at the primary legal issue through the lens of the interdictory requirement to show a reasonable apprehension of harm. And the logic that was applied by the court in essence is that an applicant can only seek relief against an identified party insofar as an applicant can only really entertain a reasonable apprehension of harm in relation to a specific identified party. So the applicant must therefore establish a factual link between some unlawful action and establish that reasonable apprehension of harm in that way in relation to identified respondents. And what is interesting is that the link does not seem to be based on a probability test, and it can be established through indirect or hearsay evidence, but it must cross that threshold of establishing a reasonable apprehension of harm. And the court, to some extent at least, throws employers a lifeline in relation to widespread and ongoing unlawful actions, which may lead the court to infer collective involvement by a group of individuals acting in concert, which is therefore somewhat easier in relation to that type of situation. But of course, the guidance we don't necessarily have that does form the subject of a useful debate is what does that actually mean in real terms? But what the court also says is that to escape the inference of involvement in such circumstances of widespread and ongoing unlawful action, members of the identified group that is potentially linked to these actions would have to disassociate themselves actively from those actions. And again, it's obviously a debate to be had as to what that means in real terms. There's also a further lifeline in a certain sense to employers in circumstances where parties acting unlawfully intentionally frustrate the exercise to identify them. And the implication seems to be that what the court is prepared to do is in circumstances where parties make it very difficult or impossible to identify themselves, to cast the net somewhat wider in terms of inferring the involvement of a broader group of people. For instance, in a strike scenario, potentially then one would assume the strikers in circumstances where the identification exercise cannot proceed. So that is really the core reasoning that the court applies. And as I've said, I think that what is going to be interesting is how some aspects of this is likely to be interpreted over time. Thank you, Peter.
Yeah, Fritz, well, we thank you very much, Fritz. we've now given the legal background, we've given the legal arguments, and we've given the factual background. What we now turn to is a sort of discussion between our panelists, and also to discuss or deal with any questions or comments that our audience wants to deal with. When we were preparing for this seminar, or webinar, I should say, we had an interesting debate as to what the importance of this decision is. The point is that it is a final interdict. And Irvin, you had some points to make about what will be the case with our interim interdicts granted. Over to you.
Good morning, Peter. Good morning, viewers and fellow panelists. May I start by saying that I'm not sure that this particular judgment is saying anything that hasn't been the law for any amount of time. I think that's always been the requirement in the law. I just think that we've all fallen into the situation of a comfort zone where we don't seek diligently to link misconduct to individual participants. And just to set out the landscape, one normally asks for an interim interdict before you actually come back to court and ask for a final interdict. The Constitutional Court here was dealing with final interdictory relief. Now, it's clear that when one is asking for an interim interdict, the bar is a lot lower. Fritz has touched on the fact that what the requirement is that with an interim interdict is that there must be a reasonable apprehension of irreparable and imminent harm. So that's the principal requirement. It's also accompanied with another requirement that the balance of convenience must favor the granting of that interdict. With final interdicts, on the other hand, there has to be a clear right, and the injury must actually be committed or must be reasonably apprehended. Now, it's quite easy to actually show at an interim level that you're anticipating harm occurring, bearing in mind that you don't have to show this in a balance of probabilities, as would be the case if you were, for example, trying to prove an assault by a group of amorphous people. You know, that balance of probabilities test doesn't apply. You must just reasonably set the platform that you anticipate this harm to occur. What's also interesting from this particular case is that the Constitutional Court referred to the Labour Court decision by Brassey in Polyoak. And in that particular case, what you had is Judge Brassey remarking about the difficulties that are often experienced. We all know that when you bring these interdicts, they're often brought on short notice, they're brought urgently. You don't have the luxury of time to actually go out and get affidavits from everybody. And in that particular case, importantly, what the court said was that it's fine, you can even lead oral evidence. And we've done this before. You have a situation where, you know, you don't have affidavits, you can call people to give evidence. The learning bit is, however, that before you come back for your final interdict, make sure that you put up supplementary affidavits, make sure that you get a transcript of that particular evidence. And the court seems to have accepted that you can do that at an interim level. The second issue, which I think is important from this decision, is that we were dealing in this particular case with a protected interdict. This misconduct occurred in the context of a protected strike. In instances where one is dealing with unprotected strike action, it seems unlikely that the court is going to exact an onerous test as this, because even if you look at this decision, paragraph 41 is important as well, because it says where a person lawfully exercises their right to protest, but is interdicted, that person's constitutional rights are impermissibly denuded where you interdict them. So if the strike is surrounded by misconduct, as the court said, and the strike itself is in essence unprotected, my sense is that the court would be more inclined to grant the interdict than not, even at a final stage. Then the third point is, you know, we're dealing here, the court did not say that common purpose actually is thrown out the window. So and I think Fritz alluded to this as well, that in instances where you can show that this is all part of a scheme, you don't need to individually link the individuals to the misconduct, as long as you can show that it's part of a scheme and people don't dissociate themselves from the wrongdoing. Thanks, Peter.
Jan, your comments on this argument and how you feel about what your views are on this issue?
Thank you, Peter. So, I mean, agree with Irvin. I think, though, that while it is correct that the law that the Constitutional Court has reminded us about is not new. I mean, we know the law regarding interdicts, and we know the need to have a link and a reasonable identification of wrongdoers. The reality is that, and Irvin is right here, we've all gotten away with going to court on an urgent basis and obtaining an interim order on sparse assertions in founding affidavits. And I think the learning here is that the courts have now come to the conclusion that, and certainly in my experience, this has been building up. I mean, we've got a long line of cases where the labor court has been saying, and maybe arbiter, but now we know that this is going to be an approach, in my view, that the strategy of employers to come to court and obtain interim orders with no intention of obtaining final orders will be carefully looked at. That's my impression of where we're going to. So while I completely agree that we have gotten away with things, we need to be a bit circumspect now. So going forward, my view, the courts and the judges in the labor court are going to be looking more carefully at founding affidavits. I agree with Irvin that where we have an unprotected strike, the bar is not going to be set as high, but I still think we must, as representatives of employers, make the effort, if possible, to link at least some clearly identified individuals to the alleged misconduct, so that we can get by and pass muster on what I think is a clear indication of our courts that the days of simply obtaining an interim order because you showed on the face of it unlawful behavior by a group of unnamed individuals, I think is going to come to an end. So we need to be a bit more savvy about how we ensure our papers comply, in my view.
Thanks, Dion. I actually see paragraph 43 of the judge, which is quite an interesting one, where it says the court makes a point that strikes are unfortunately blighted by violence and deplores this. And then it goes on to say, at the same time, courts have warned that interdict proceedings are susceptible to abuse by employers with ulterior motives. And to me, that is the crucial point. There's almost like a warning in this regard there. Fritz, sorry that I see your hands up?
Yes, Peter, the two things I'd just like to remark on in that regard is I think that where there is going to be an impact from this judgment is in terms of how we frame things in the affidavits that we put forward to the court. I think what will happen is that one will have to track the language to an extent that's been suggested. And in terms of populating that language, I think, again, one is going to have a different approach in terms of attaching language to particular factual assertions to make sure that this linkage is quite clearly demonstrated. So I think it will have some practical impact. I tend to agree that I don't think there's a radical shift in the law, but I think in terms of how we practically approach things and how we approach the courts, there is going to be a difference. And the significant warning from this matter, because I think that this is where things might have gone awry to some extent for the applicants, is that one must not fall into the unfortunate position of promising certain things by way of saying we can show this through videos and through so forth, and then not actually following through by doing that in due course and probably at least before you come back to court to seek final relief. Because I think that's where, to some extent, this went awry for the applicants. So I think those lessons are going to be important going forward. Thank you.
Thank you, Fritz. I see Irvin's got a comment to make. Irvin, I think you're on mute.
I agree with Fritz, Peter. I think what was interesting about this particular case, and also in a sense sad about the actual facts of it, was that the judge here referred to 3 cases where previous judges had warned about the importance of linking individuals to misconduct. And that was the Polyoak decision, the O'Connor-Brick decision, and the Noordin case. However, if one goes and reads those particular cases, you will see that in all three of those cases, the court actually ultimately came down and granted the interdict in favor of the employer, or in favor of the party seeking the interdict. And the key point that comes out of all of that is the court said, we accept that it's not going to be possible in all instances to link individuals to the misconduct. You've got to at least try, I think, as Dion said. And secondly, where you can actually show that they're part of a cohesive group, that will pass muster. That's sufficient to constitute for the purposes of an interdict. What was sad, on the other hand, about this particular case, and I think it links back to what Fritz is saying, is that it appears that, the employer here did have videotape evidence, they did have photographic evidence, they just didn't get that evidence in before the final interdict was sought. And the court strings onto that a caution to parties, even if you're going to be seeking these interdicts, make sure that you put that information up so that it is factually supporting your case for a final interdict.
Thanks. Valandili, I think if you can give us some sort of indication, we now know what the law is and the problems there, but what is interesting is how the court approached the granting of relief and what it said about the various different groups of workers and what practical steps we can take in this regard. Would you want to comment on that?
Thanks, Peter. I think, as has been said by my colleagues, what is pitiful about this case is that there appears to have been some available evidence. It just doesn't seem to make its way to the papers before the final determination of the matter. But before I get into that, I think what it really all comes down to, in my view, is effective strike management. And our clients and employers know this, that strike management is the key to a successful interdict, if that is one of the tools that an employer decides to invoke in that process. And some of the work can be started long before there's a strike. So something as simple as making sure that your database, your employee database, is up to date. That's the kind of work that can be quite useful when you find yourself in this circumstance. And so it's things like making sure that your employees' photographs are up to date, things like making sure that you have access or you have the latest cell phone numbers and contact details of employees. And to illustrate how this becomes important, if you look at one of the examples or one of the incidents that are cited in this case, it's a case of arson. The allegation is about 5 unnamed employees went onto the field and tried to set it alight at least twice. The employer then says, we have video footage. In the fullness of time, we will take disciplinary action against those. That infers that given enough time, they can identify these persons. And my view is, we don't have full insight as to what is happening in the background. But if one had a readily available repository of the photographs of the employees, and given them, it's a relatively small number of persons that are on strike, the employer should have been in a position to identify these employees if it just had access or timeous access, let me put it that way, to the photographs of the particular employees. One of the other issues that is mentioned is in relation to the intimidation incidents. The court says there is an allegation that people were intimidated, but it's missing detail. How was this intimidation? Who did it? Was it by telephone? Was it by text message? They say there's no text messages that are attached to support this. Again, intimidation can take various means. And to the extent that intimidation happens by way of text messages, it is quite helpful for an employer to have access to the recent cell phone numbers of employees. To the extent that they use those cell phone numbers, you can immediately link that kind of conduct to a particular person. So it's that kind of practical stuff, I think, that we can take into cognizance. And of course, keeping a strike diary or whatever it is that different organizations call it. We know that's quite important, but it's also what you put in that strike diary that becomes even more important, because what it really impacts on this particular employer's inability to get a final interdict is the absence of specific detail. So when incidents are being recorded in this diary, the what becomes important. What is the incident? The details around it. Who does it? If to the extent that people have been identify them as best as you can. It's Mr. So-and-so and Miss So-and-so. And if it is a group of people, it is a group that walked to the incident using this part, and try and see if you can trace where they start walking, because very often where they start off before the unlawful conduct can help you in identifying them. I mean, I'm reminded of one case, Peter, that we did, where the employees concealed their identity. They went off about and they performed all the misconduct, and you could trace them through a series of video footage as they walk back to the hostels, and they still conceal, but then they use access cards to enter. So even though you cannot say, there's no direct evidence saying that it was Balindile who was at that scene, you can trace that, and by placing her at a particular scene where you can finally identify her, the circumstantial evidence adds up. So it's that kind of detail that becomes very important. And then the one, I think, cautionary tale here is probably how we catalog evidence, because there's many forms, right, that we can use for evidence, and especially video evidence. We can get it through CCTV, we could get it through handheld devices, and now our cell phones have become very useful tools in taking videos. But also then how you catalog it and place it into a repository. I think it's very important in the strike diary to say, this is the incident that happens. There is video footage saved at this particular place, so that when you are under the stress of having to put together your papers, you can easily find that video footage, and you don't find yourself in this example that Fritz sets out, where the court says, you've promised the video footage, it didn't come. So it's just practical things that we can do to, number one, get the evidence as best as we can, but also enable us to easily access that evidence when we need it under stressful circumstances. The next thing I think that is also very important is how we use picketing rules. And Dion, I think you made a very good point yesterday in our earlier discussion. We also need to be sensible about the picketing rules that we impose or that we ask for, or that in the sense that they must be workable. In this particular instance, the employees or the demarcated area is some 800 meters away from the gate, and the employees ultimately get frustrated with not being able to be within a visible space, let me call it, of the customers and the suppliers, etc. And that in itself has an influence. But what I want to say is that once you've got a demarcated area, I think it's very important to make sure that your surveillance around the demarcated areas is up to speed. And also, and especially the areas where our customers, employees, and suppliers need to give access to the workplace, the surveillance around those areas need to be absolutely up to speed, in my view. So those are the kind of things that I think are helpful from a practical perspective. And of course, sometimes we have to live with the fact that we won't get everyone's identity, and that's okay. If you are able to specifically identify the leaders, for example, of the unlawful action, the people who are inciting or instigating the unlawful action, and you are able to name them specifically, I think in certain circumstances, strategically, that is possibly even more useful. So maybe let me pause there for a moment and see if any of my colleagues would like to add anything. Irvin, I see you have a word or two.
Irvin?
Yeah, thanks. I think that's a very useful practical guide, Bali, about how one should actually anticipate having to go for an interdict. And I think it should, as a matter of course, be done whether or not you're intending to go for an interdict or not. It's just part of good industrial relations strike management process. But what I also think is important is one needs to keep a clear audit trail of correspondence with the union, because one must bear in mind that the union is the collective bargaining agent of the employees, and where things start coming or start going awry, you at least want to cite the union in these interdict application papers. And I think it's quite telling in this particular case that the interdict was effective against the union, because the union could not effectively dissociate itself, from the misconduct that was taking place.
Exceptions in the act. Dion?
Yeah, thanks, Peter. I think, the practical steps that employers need to take, again, this is not reinventing the wheel or rocket science. I think the approach must be one of just common sense. Common sense when it comes to the strike and picket rules. Common sense when it is that you instructing your security personnel, your IR personnel to keep tabs on the strike action, on how they go about maintaining a record of the strike diary and overall the strike management. It's about understanding that if there's a need to go to court, these are the essential things that we want, and so you need to look out for them. If you see people that are intimidating, make a record of it. Record the people that you can identify. Take photographs, take video. It's what we would do. I suggest in circumstances where we're not under pressure, and I think that's the message here. Employers, I think the courts have now told us that this is how we're going to be looking at interdict applications, and so we just need to be aware, and we need to educate the people on the ground around these issues, so that we're not left with pressure at the time, because we all know we've done it. The interdict needs to be drafted in a matter of hours, and people are scurrying about trying to find information. I think Bali is absolutely correct. The strike management starts well in advance, and the only additional point I want to make is let's educate the people on the ground so that they know what is required of them.
Thank you, Dion. One question that Balandili may be able to deal with is this, well, all of you may be able to deal with, is this issue of we have to run around to get interdicts to get information from people. Is there a possibility that what we should be doing, if the strike is unprotected, that can be proved relatively easy through affidavits? Is it possible to go to court first to get the interdict, but to say in your papers you will be bringing at a later date an interdict against violence? Is that an option that can be utilized? Yeah? Bali, yeah, sorry, Bali.
So I think it is absolutely appropriate, and we've done it a number of times, where we bring an application to deal with the unprotected nature of a strike, and then on another occasion we bring an application in relation to interdicting unlawful conduct associated with the same strike. So I don't think that there's any issue there. The only question, I guess, is where you foreshadow in your first interdict that you're going to be coming back for a second interdict. You would just have to deal with the question of urgency. So I mean, it might be strategically appropriate to do so, because it might be in a day or two. But if the facts are already known to you, I think we all know you must bring this to the court as early as possible. But if the facts are not known to you, then I think that maybe you won't be in as much trouble if you foreshadow in your first application that you'll be coming back a second time. But the idea of bringing two sequential applications for me is not an issue at all. And it also just gives you enough time to gather the right evidence and to place yourself in the best possible position. Dion, I know you wanted to add something.
Dion?
Thank you. Yeah, I completely agree with what Bali has just said. There's no bar to doing what you've described and what Bali's described, but you can absolutely bring a second application for unlawful behavior and unlawful conduct. But Pak, I also see that we've got two questions that have arisen. Maybe I'll deal with the one. I don't want to take up all of the time here, but the question here is around the breach of picketing rules, which obviously the CCMA has jurisdiction, and what will happen if the matter hasn't yet been heard. It's been referred, the dispute's been referred to the CCMA, but as I understand the question, not heard because it's unlikely to happen before the urgent application for an interdict is heard. And the question is that sufficient? And the simple answer is yes. Our courts are very clear on this question. And now the Labour Appeal Court in this Oak Valley decision has confirmed the position. And the position is this: it's a requirement in terms of the LRA that for alleged breaches of picket rules, that a dispute be referred to the CCMA prior to the urgent relief by way of an interdict being sought. So all that's required is compliance with that referral, and that will be sufficient for the court to then deal with the issue of granting an interdict for those alleged breaches.
I suppose the point should be made is we're all concentrating on the interdicts that be granted, but at some stage or another, you'll have to prepare for an arbitration on whether the picketing rules have been breached. And well, maybe the employer will say something along the lines of, well, I don't want to carry on, I'll withdraw my dispute in the CCMA. The matter's settled, but a union may decide that it wants to deal with this issue at some stage or another. I should also say that there's also, as happened in our case, a union can anticipate the order and come at an earlier date for a final order, and that, or to oppose a final order. And I think that's an important point. Fritz?
Yes, Peter, I see there's also a question, and it's one that we've obviously thought about before and taken advice from lawyers that are specialized in that particular field. It's around the POPIA Act impact of video footage that you take of employees participating in strike action, and particularly employees in circumstances where you're trying to demonstrate unlawful conduct. And the position that's been taken is that it is processing of personal information, but that it is for a lawful and legitimate purpose and is acceptable under POPIA, and that it doesn't present a difficulty per se. Although what one would suggest is that advice should be taken in relation to what one's information processing policies say in relation to that issue of using video material.
Bali, you had something to say as well in this regard on this?
I completely agree with Fritz. I don't think there's anything worthwhile adding there. But whilst I've got the floor, the one thing that I'd meant to mention, which I think is a tool of technology that is now more easily available but underutilized, is where you don't have sufficient fixed surveillance video, whether it's CCTV or other forms of video. The use of drones is becoming more and more useful, and of course drones can move with the employees. So it's something that I think, particularly where an employer has a significant collective bargaining activities within them, it's something that might be worthwhile investing in to the extent that they don't have it. Of course, then couple that with Fritz's caution from a POPIA perspective.
It's mind-boggling, really, that we have to consider this in this day and age to monitor our own employees through these drones. I agree with you, but it's still, we're in a bad position as far as that's concerned. Irvin?
I think that one needs to also just look at this from a holistic perspective. You've got employees that are engaged in misconduct. I mean, you're not going to require that information only for the purposes of the interdict. You're likely to have to require that information when you are disciplining these employees, and probably at a later stage when these employees take you to the labor court on the basis that you've unfairly dismissed them. Just bear in mind at that stage, you've got to prove your case on a balance of probabilities. It's not a reasonable apprehension there. It's on a balance of probabilities. Your body of evidence is not going to get any better than it is as that particular misconduct is taking place. So it's twofold. It's to use as arsenal in your interdict proceedings, and potentially at a later stage to use when you are dealing with your misconduct inquiries, and then, later for progeny's sake at the labor court, if you need to defend an unfair dismissal case.
Thank you. Fritz? I think you're still on mute, Fritz.
There we go. I committed the sin of all sins. Yes, just to underline what Valandile, Irvin, and Dion has also said about the way one approaches this practically. I think that where things often go wrong is when employers start thinking about strike management when a strike happens. One does need the rigidity of having a plan and having some processes in place to manage strikes well before they happen. Because the difficulty is that if you start thinking about it in the midst of the drama and often the traumatic events that accompany violent strike action, that's very often when the information gathering goes awry. And it's for that reason that I think one needs a rigid approach in terms of having proper policies and approaches in place beforehand.
Thank you. What I find interesting is that we've been talking about the employees or the strikers, but what evidence will be required if you want to interdict the union from inciting violence? How can you link a union itself to those to those unlawful acts, and can you do it in some form of that? Valandile, have you got any? Remember, you and I debated this. What have you got any views on this?
Thanks, Park. I think to link on to a point that Irvin has made, our courts recognize that the trade union remains a relevant player in the context of bargaining, of collective bargaining. So in the first instance, and the importance of communicating with our trade union, particularly during strikes, is very important. And the moment that you either detect that unlawful conduct is imminent, or you detect the actual unlawful conduct, the importance of immediately communicating with a trade union, be it by email, fax, if people still use fax, and WhatsApp is becoming even more and more important, because that blue tick is quite useful because you can show that the recipient has read the actual communication. So from that perspective, it becomes important. And of course, in this case, one of the reasons why the employer is able to get the relief against the union is because there is correspondence from the union official where he says to the employer, the emotions and the frustrations were running very high, and the strike would spill over into the community. And lo and behold, following his address to the community, the strike spills over into the community. So that kind of evidence is quite important. Of course, in this case, it was quite useful that the union official had also been arrested for incitement of violence. So that kind of evidence becomes very useful, but primarily communication with the union officials is by far the best tool, because then you bring it to their attention, and because of their proximity to collective bargaining and their importance as collective bargaining agents, they have to actually do something to disassociate themselves with the violence, and that one becomes a little bit easier, in my view, to establish, unless of course the union disassociates itself.
Dion, I see your hands up, and Dion. Dion, you got your hand up?
Thank you, Peter. I see a question in the chat box that I think I'll read so that the context is clear, and then maybe my colleagues and I can discuss it. So The question is, employers within the retail industry have many sites wherein there would be picketing activity. The court said where the strike is substantially peaceful, only those who associate with the unlawful conduct will be interdicted. Now, to contextualize what substantially means, do we count the number of sites where unlawful conduct takes place, or the ratio of the number of employees participating in the strike versus those participating in unlawful conduct? So my view on this is, it's not a question of trying to identify what substantially means in terms of either workplaces or participants. The issue is the courts are clear and our law is clear that in order to succeed with interdicting any individual from either committing or participating in unlawful conduct, that individual against whom you want the interdict to be issued must be linked and identified and then linked to the alleged unlawful conduct. So even if you had one individual at one workplace identified as having intimidated fellow employees, that would be sufficient to obtain an interdict against that identified individual. So the issue for me is not one of as I said, trying to interpret substantially. It's a question of, can we directly link somebody? If not, can we sufficiently link individuals to unlawful conduct? And to assist employers with that, as both Irvin and Fritz have said earlier today, we still have the ability in law of the common purpose principle. So where we can link individuals because they were there, they did not directly extricate themselves from the group, etc. As long as we are able to sufficiently link people to the unlawful conduct, you'll be able to obtain the interdict against them.
Thank you, Fritz. Yes, what interests me is how the court talks about the employees must disassociate themselves. How do you get that to be done? Do you write letters or emails or you know, how do you set out a brief, and will it work for that matter? And Fritz, I see your hand was up if you got any comment on that.
Yes, I think it's one of the things that the Court has left wide open in terms of exactly how one gets into that category of collective involvement, demonstrating that there's sufficient widespread and ongoing unlawful activity to show that cohesive nature of a group of people acting in concert. And I would suggest that in terms of the question that's been asked, that what an employer would do is put its best foot forward in terms of the facts that it presents to demonstrate that it falls within that category. But there's no pat recipe. The Court hasn't assisted us to that extent, and hopefully what we will have that will emerge from case law over time is what type of behaviors, what type of situations fall within that category. But it most certainly hasn't been made particularly easy in terms of interpreting what that means. Similarly, the disassociation issue, as Dion quite correctly says, and as you say, I mean, how do we get there? I'm not sure that there's anything particular that the court has put forward in that regard. Is it a statement? Is it through conduct that a person disassociates? I think that's going to be a developmental area in terms of our law for some time to come.
Irvin, I see you have your hand up. Do you want to comment on that?
Yes, I think Fritz is correct that these are certainly going to be difficult waters to charter, and we're probably going to see quite a lot of the decisions being based upon considerations of this issue. But what I did think was important is that, the civil courts have never got to this situation that our labor courts have got to. In the civil courts, if you're seeking an interdict, even under the Regulation of Gatherings Act, the courts have been exacting in requiring you to actually link individuals to acts of misconduct or acts of misbehavior. And interestingly enough, in this particular case, what that referred to the Polyoke case, the court basically said in Polyoke that, that linking can occur by association and instigation. So oftentimes, and we had a situation here where you could refer to previous correspondence where the union was directing people to do this, that, and the other. And that correspondence was sufficient to establish that particular link.
Right. What interests me is, and I think Bolly was involved in the case with me, one of our clients was we were trying to get an interdict against the union. And what our client did was to go to the union's Facebook page. And there you found ample evidence of incitement, calling on employees to do this, to do that, to do following. And we were also to establish some sort of link with individuals as well there, in terms of looking at Facebook pages. Is there any problem with that? We got our interdict on that basis, but you know, there may be evidential problems later on. But, do you think it's a valid thing that we should be doing as sort of almost routine?
So, Pak, just because I was involved in it, I have a slight bias. Of course, there's no problem with it.
Okay.
But it's a very useful tool, social media, and having someone manage that particular portfolio during a strike is very important, because also unions are smart. When they know that when they realize that you are observing their conduct on social media, they also take things down. So it's very important, in my view, to have someone whose part of his functions is on a daily basis at different intervals to look at what's going on social media and take screen grabs, save things, because they are smart. At some point, they'll realize that you're onto them and delete it. So in my mind, it's a useful tool of evidence.
I think so. Dion, you've got a hand up.
Thank you, Peter. Yeah, I wanted just to add on to what Bali's saying. This is a question of evidence. An employer is entitled to go and gather evidence to support its position. So for as long as that evidence is relevant and not inadmissible, then we can use it. So if you're able to gather evidence through social media, absolutely. And our laws are clear on this. So as an employer, gather the evidence. The lawyers will then assess whether that evidence is relevant and admissible. And you know, we'll have fights around admissibility. And for as long as we are able to deal with that properly, that's the practical issue here. Takeout here is gather the evidence.
Yeah.
And I see there's a follow-up question to the one I read, and the question was, what can a company do in the following instance? I guess that's a follow-up on what can you do where you can't identify people, but maybe only a small number. My answer to that question is, again, if you are able to identify a small number, that's what you put in your papers, but you also have the ability to try and extend that number based on the discussion we've had around common purpose, etc. That's what an employer is required to do.
You're on mute, Fritz.
There we go. Thank you, Peter. Yes, in terms of where one lands with that form of evidence, it's actually particularly persuasive because it's so difficult to disavow. It's like the effect that things like emails have also had in the litigation world overall, is that it's very hard for a party that has said certain things in a particular electronic forum to prove that is not their communication and that it's not their intent to communicate in a certain way. So I think it's extremely valuable, and I think it's something that really changes the whole shape of how one presents a case quite often.
Yeah. Well, I see we've now gone well over our 40 minutes, is now an hour. I hope you enjoyed the seminar. We found it interesting, I must say, and thank you for your participation. There was one question about dealing with what's the full citation for the site, for the case. We are informed that it will be on the slide or posted on this video just now. It's also available as SAFLI. If you know the SAFLI website, you can go there. It's available there. It's full reference under the Constitutional Court is there. Thank you very much. And thank you also for my fellow participants. And we hope to see you in future webinars as well. Thank you.